Hey guys, Scott from Aristocob.com here.
And Seth from North Carolina.
I have no idea what I was just looking at. My eyes were over here.
Really?
Yeah, I don't know.
Let's look over there then.
And together, the three of us, we are Markwood Men's Breakfast Club. Welcome once again.
Good morning.
Sometimes I surprise even myself. There must have been a shiny object over there.
Yeah. Not
Actually,
a bird this time. Sometimes it is a bird.
I think it's a gallon of Tight Bond glue that I didn't know was sitting over there. So
congratulations.
That's what caught my eye, yeah.
You have some glue.
I have a lot of glue. I got Gorilla Glue as well. But anyway, so welcome back. And we're going to continue on a little bit on a topic that we started last week.
Which is chocolate tobacco.
Okay.
From the gas station around the corner. It's in your yellow bag.
Yeah, so...
For easy travel. So you never lose it.
So, yeah, we'll give you our opinion of the Super Value chocolate tobacco, which is actually manufactured by Sutliff. I'll tell you, it was fine. It was a fine tobacco. It's tobacco. All of that at a head shop was $15. You're going to find it for less than that at a drugstore.
I've had a lot worse.
I've had a lot worse. It was fine.
Yeah.
So, I don't know that it's one I'm ever going to crave.
Should put this on your bag so that you never lose it.
I'm not sure that would stick to the bag, but... Don't forget, if you're interested in one of these official Markwood Men's Breakfast Club stickers, send us a self-addressed stamped envelope. The address will be below in the doobly-doo, and we'll get that off to you pretty quickly. Today, we're going to crack into the package of samples that were sent by My Secret Santa. Now, My Secret Santa sent along some sealed tins as well, but I'm really intrigued by these. And also, the sealed tins are sealed. They'll be good to go for a while.
Yeah.
These I want to go ahead and smoke. One of them, actually we've had two of them. We had the 1981 Carter Hall. I smoked the heck out of one that I think is still out in the car.
Thanks for sharing, pal.
Sorry, it was really good too. Really good. And today let's smoke, let's see. Let's smoke some 2011 Mac Baren Symphony.
Alrighty.
Thank you again, Santa. Philip, really do appreciate. Wonderful gift that keeps on giving. Seriously. Let's see. So we talked about the sticker. We talked about the tobacco. We'll get that started. So continuing on the conversation that we were talking about last week about trademarks and about the Kids React, that reminded me of a story of a lawsuit that took place just a couple years ago, and I need to Google this real quick. Maybe I'll talk about this and let Seth Google it. There's a power tool company called Jet. If you're a woodworker, you've heard of it. They import almost all their tools from Taiwan and China, and most of their tools in the early days were clones or copies of the Delta and the Powermatic tools. So right off the bat, their whole foundation was built upon copying their competitors. But it's okay because those products had already, if they had been covered by patents, those patents were long in the public domain, and what they were doing was on the up and up. Their first tools they brought into the U.S. were just okay, but as they decided that this was going to work for them, they started putting more effort into it and using better quality bearings and upping their game. And one of the things they did was they changed the colors of their tools from blue, the original color, to white. And they trademarked the color white. Don't ask me how, but that's what they did. That was their trade dress. Fast forward a few years, and a company called Woodstock. Woodstock is a wholesale company that sells woodworking equipment to retailers. And most of their tools, their power tools, are sold under the brand Shopfox. So as Seth is Googling this, he may actually have to search Jet versus Shopfox.
Sorts of things.
But they, after coming on the market and having some initial success, they changed their color to white and then ran afoul of Jet. So Jet sued them for the trademark or trade dress infringement. Who would have thought that you could trademark a color? But you know, Harley Davidson trademarked the sound of their engine. Sounds like your computer coming
Under
on,
pressure.
or we got mail, or any of those things can be trademarked. Some of them are covered by copyright, but it's fascinating, the stuff that can be protected, and rightfully so. You know, when you have Intel inside, ding, 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 you don't need some other company using that sound. What they used to call that on radio and television, their call.
Their sign, wasn't it?
Like, you know,
Their call signs.
NBC, ding, ding, ding.
Yeah.
That goes way, way back to radio. And all that stuff is trademarked, protected. What are you learning there?
I'm seeing it's 3 companies, actually.
Okay.
3 companies. It is Grizzly, Woodstock, and Jet.
Yeah, okay. Grizzly is owned by the same people that own Woodstock.
Grizzly International and Woodstock International prevail in 7-month battle with WMH Tool Group over release of machinery detained by U.S. Customs.
So Customs had stopped them at the border and
Took all of the ones that were white and green.
in green.
Yep.
Why was Jet holding on to green? Because green was Grizzly's color. That's interesting.
WMH convinced CBP to seize our clients' off-white and even their green and tan machines directly from our clients' exhibitions during a major trade show in Las Vegas, based on a U.S. trademark registration that is likely to be found invalid. Same day the machines were seized at the Las Vegas trade show, Grizzly and Woodstock applied for emergency relief in federal court in Chicago, and the district court issued an order temporarily restraining WMH and CBP from seizing Woodstock and Grizzly's machines at the trade show. This is 2007.
The show was AWFS.
The dispute started in July 2007 when WMH filed suit against Woodstock and Grizzly, alleging trademark infringement and a host of other charges. Grizzly and Woodstock claimed that WMH Tool Group could never have acquired trademark rights in the color white because of prior third-party uses of white and off-white colors on woodworking and metalworking machines. Moreover, Grizzly and Woodstock claimed that WMH's trademark registration is invalid and subject to cancellation for fraud on the U.S. Patent and Trademark Office in the procurement of the registration. According to the evidence, WMH claimed first use of the color white in 1996, but at the hearing in federal court in Chicago in 2008, WMH's own witnesses admitted that WMH did not use white on woodworking machines until 1998. That WMH did not use white on at least 2 machines that it alleged use on, contrary to the rules, and that WMH failed to disclose competitors' prior uses of white as required by the USPTO. Mr. Schmidt suggested that these missteps may cost WMH its trademark registration.
So this is then before it was settled, right?
Yeah.
You're reading about them getting their product released
Yep.
that had been impounded. That sucks.
Yep.
Now, some of the irony involved in all this is, again, many of these tools were copies, and in the early days, Grizzly and Jet were both copying Powermatic and Delta.
Right.
Powermatic, which is now owned by, is it WMH?
Yeah.
Powermatic is now owned by them, and I want to say even Delta is owned by them. I could have my facts wrong there. There's been a lot of mergers and acquisitions. Powermatic, Porter Cable and Delta used to be one company under the Pentair. Well, even before that under Rockwell, and then they split up, and now I think it's the people who own Skill, Skill hand tools and scroll saws and things. They now own several brands, including Porter Cable. A lot of that incest that goes on in that industry. It's so hard for them to stay afloat because their profit margins are so low.
Right.
Anyway, all that said, this whole trademark thing and patent thing is really interesting to me. A lot of folks don't understand, and I hope we haven't talked much about this in the past, because I don't want to be repeating. A lot of folks don't understand what the whole patent process does, and it was created in the United States by Benjamin Franklin, who
Crafty Franklin.
he understood that the European method of passing knowledge on through interns and through education,
apprentices,
that's good, but it was very slow for technology to advance in that way. And so his thinking was, all right, you invent this. You want protection. You don't want your competitors copying this. Well, we'll grant you that permission. But in exchange for a 7-year, now it's 20-year protection, you have to disclose your secrets. You have to tell us exactly what it is about this pipe that makes it different and better. And all of that then gets explained in the patents in a section that they call the claims, where you're claiming what's unique about your product. Now what's interesting is you might find a patent for this and go, oh, I can't make that pipe I want to make because, look, it's patented. But it may be that only this part of the pipe is actually claimed to be the innovation. So you really have to know what you're doing when you're reading patents, and that's why you hire patent attorneys. When you go to patent your product, they go and they research all these previous existing patents, and they may find that this part of the pipe that you are claiming is unique was actually used on a musical instrument or used on a candlestick, and therefore you're not going to be granted your patent. So it's very interesting. You have to study patents to make sure. I worked for a company that had a product that a competitor, upon first glance, thought was a copy of theirs because they got a patent on that thing. But no, their patent was on this thing, and we didn't copy this thing. The other parts that looked very, very similar, they didn't have a patent on. There's a drawer slide manufacturer that has a patent on a roller that helps to support the drawer as it comes out. It's a little plastic roller. Otherwise, it's a ball bearing and roller slide, very, very high weight capacity, great durability, full extensions, 48-inch wide drawer capacity. This is it's made by Grass, and it's called Dynapro. Some of their competitors assumed, because they didn't find a patent for that drawer slide, that roller was not patented. But that roller was patented 12 years before on a whole different drawer slide. So you look at the patent, it doesn't look at all like this product they actually came to market on, but their claim was on that front roller, front support roller. So again, you kind of have to know what you're doing when you're going to take a risk and say, I don't think my idea is infringing on their idea because my pipe doesn't look like this, right? So the whole conversation came up in talking about the Chris Morgan Briar cigar. Where's my Briar cigar? I guess it's in my bag over here. Chris has got a patent pending, so he started the process of the patent process, and that whole patent pending, there it is. The patent pending puts other people on notice that he's applied for this patent. If you want to make a pipe just like it, go right ahead, but just know when he's granted his patent, you're going to owe him a whole buttload of money. And there have been pipes like this for over 100 years. So at first glance, you might say, well, he's not going to get a patent on a pipe that's shaped like a cigar. But the unique features of it that are claimed in his patent have never been done before in that style of pipe. So you could run afoul of his patent if you copy that.
But let's say that the unique feature is the bit.
Okay, let's say that.
Right.
It's not. Let's say.
That's hypothetically, if you had one and yours used a totally different style, then you'd be in the clear. Right?
As long as it's not just the style, it depends upon whether it's a design patent or a utility patent. A design patent, it's about the looks of it. A utility patent is about the function of it. And so if you change the shape of it, but yet maybe internally, maybe it's got a venturi or some feature that affects the way it smokes.
Right.
You might make yours look different, but you can still run into trouble.
Okay. So if that's the case, then how is it that every gas station has Chinese iTunes, iPhone charging cables that are not licensed?
That's a really good question. I know in many cases the unique features, the patented features of some of the iPhone chargers are not the fact that it's shaped like a lightning charger, but internally on a lightning charger there's a chip. Mm-hmm. That's part of it. So you can copy it without a chip, and maybe all you're doing with your cable is you're allowing the power to pass, but you're not allowing the data to pass. Mm-hmm. That may get you around the patent, and that's true in some cases where some of the lightning cables will charge, but they don't do squat for data.
It's interesting. There's a show out on AMC called *Halt and Catch Fire*. It's a fictional show about a fictional computer company in the '80s that copied. One of the very first things that they did is they took a.
But the show itself actually exists, right?
Yeah, the show's excellent. It is.
It's a show of fiction?
Yes. They took a... I forget the brand computer. It's not a Mac, but it's...
like a PC?
No, yeah, but it's... Whatever the big name was at the time. And within the very first few episodes, they take it apart and they reverse engineer it, and they
so it was the IBM then. So
yes,
the IBM PC is what everybody copied.
Yeah, so they figure out what the code is, and then they create their own version of the code. Mm-hmm. And they get into a bit of a legal battle there, because the question is, are you using the code? What's being copied? What isn't? It's an interesting conversation about to be had sometime later about how much of your knowledge is proprietary and owned by someone else, right? Because if you work in a company where they've trained you and they've taught you processes and they've given you knowledge, and you leave that company, if you have any sort of non-compete clause or confidentiality agreement, how much of that's enforceable based on the knowledge that you have? Because it can't be removed. You can't take that away. Yeah. And you can take that, and if you take what you know and you build on it, how is that come into play? I always had that question with professors, college professors in school. When you're writing a college level paper, one of the things that they tell you that when you're writing a paper is you should always cite any source where you learn something that you didn't know. But then they also tell you that you should never, ever, 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 ever cite Wikipedia.
Because that's not a source.
But oftentimes, Wikipedia is a great resource to lead you to better sources.
Right.
But if you learn it from Wikipedia first, and then you follow the trail to a better source that you can, a quotable source,
right,
shouldn't you, because you've used it and you gain the knowledge from Wikipedia, cite Wikipedia?
I mean, but that would be like if I told you, hey, I know where you can find this information, you wouldn't cite me.
But if you told me, hey, this lighter has been around for 1,000 years, I say, oh really? How do you know? You say, well, that's over here. Mm-hmm. Right? I'm gathering the information. You've given me the same information, but I'm just using the real source really just to verify that what Wikipedia said is fact. Right.
Oh, I know. I get what you're saying. I'm just saying that if I'm the one that steers you to the source, you don't quote me. You ultimately quote the authority, right? The creator of the information, not the person who said, hey, here's the information. Wikipedia is the intermediary who's saying, here's the information, here's the source. So you're right. You don't quote Wikipedia just like you wouldn't quote me. Or
I have quoted you.
It shows some wisdom on your part.
All right, Hollywood. Don't let it go to your head.
Anyway, to me it's all very fascinating, and it's all done for the betterment of mankind and the advancement of technology and ideas, so that we can build on one another's ideas and make the next great thing.
That's the intention anyway.
You know, it's like the touch screen on the iPhone or on the iPod, and ultimately led to the iPad and so on and so on, was based on a patent for a kid's toy drum. Guy invented this idea where, depending on where you tapped the drum surface, would create a different tone. So an electronic drum. The folks at Apple were researching patents to come up with ideas to help them solve this problem of how do you make this touch screen. And they saw this patent, they purchased the rights to it, and ultimately that led us to where we are today.
Right, but unfortunately, it's also what leads to a lot of ideas being shut down because of patent trolls who go out, buy patents, and then use them to extort companies that are using those resources, oftentimes without cause or without.
Yeah, I may have talked about this, like the Phillips screwdriver and screw drive that you'll find in a screw. Mr. Phillips, while applying or researching for the application of his driver, stumbled across a drive type that was better than his design. He purchased that patent, had it assigned to him, and that is actually what we know as the Phillips screwdriver. His design was not so good, but it was similar.
Yeah.
So there you go. He got both patents, actually. His, and then the one that we all know today is the Phillips.
All right.
All right, so this tobacco, I'm liking this tobacco.
Yeah, that's good.
This is working for me. Again, this is a 2011 Mac Baren Symphony.
It's a pretty coarse cut, too.
It is. It's a little dry. I have to admit, when I got these, I probably should have done something better to store them. And that one, maybe we opened and took a smell of it and didn't get it sealed right. But it's smoking great.
Yeah.
So.
Yeah, very good.
All right.
Thank you.
Recommend getting your hands on some of that if you're interested. And with that, we should wrap this up. How about you? I mean, what do you know about this whole process? Have you heard stories? You know, the whole Ready Kilowatt character is something that fascinates me because my mom worked for an electric company that used that logo and had to stop using that logo because somebody trademarked it.
Yeah.
After it was already in commerce.
And that can be done.
Tell us about it in the comments or make a video response and post a link to that in the comments. All right? And with that, we will see you guys next week. Make it a great week.
Bye, guys.